pop-up telling you it's recording? Perfect. I actually like that Zoom added that. It's helpful. So again, welcome everyone. This is our third session in our March Dementia series. Today's session is on what to do when things get messy. We have our guest speaker returning who was on our session last week, Julie Rivers. She's an attorney and we're so glad to have her here to bring you this information. I did send an email out a little while ago, about 15-20 minutes ago, that had some handouts from today's session. That way you have them for you. All the handouts that the presenter wanted to make sure everyone had. If you're in today's session, we ask that you keep yourself on mute during the session. It helps limit the background noise for the recording. It also helps kind of keep the distractions of the screen jumping around. Zoom tends to follow whoever is speaking. So anytime there is someone make noise, the screen follows that person who spoke or whoever made noise. So please keep yourselves on mute. If you haven't already, please introduce yourself in the chat. We will be taking attendance. We take attendance to make sure everyone gets credit for being here. You'll get a certificate for all the sessions during this 4-part series. At the end of the month, I'm going to send all the March certificates out at the end of the month in one group. So all the trainings you attend in March, you'll get your package together. So make sure to enter your name in the chat and say hello, who you are. I see most of the names on the screen, but I think there's a few that are names of phones. So if you can make sure to introduce yourselves. If you're not sure about how to do that, if you can reach out maybe by text to Valerie. If Valerie help recruit you so we know that you're in today's class. Make sure, before I pass on to our presenter, I want to have a quick hello from 2 of my helpers today. Valerie, want to say hi?
Hi, everybody. I'm glad you guys made it today. What to do when things get messy? Take out the trash. So thank you so much. If you guys have any questions, we had the chat, we had text, just let us know and we shall help you. So have a good class.
Thank you. Thank you.
And Bridget, you want to say a quick hi?
Hello, everyone. We'll be glad to show today and enjoy the class.
Thank you. Valerie and Bridget are helping me watch the chat for any questions. The presenter is going to do her whole presentation, and then at the end of the presentation, we'll do a Q&A for folks. So please feel free to drop questions you have in the chat, or write them down. You're welcome to just jot them out on paper too. When we open the floor up for questions, you're welcome to then raise your hand and ask them out loud as well. Before I pass it on, I realized I forgot to introduce myself. I'm Dana Howarth. I'm the Deputy Director of the New Mexico Caregivers Coalition. We are a small nonprofit in New Mexico that provides training and resources to caregivers, family caregivers, paid professional caregivers, and care recipients across the state of New Mexico and parts of Arizona. Thanks to Valerie and our partner with Valerie in reaching out to the Navajo Nation. So thank you all for joining us. We are so excited. This is a guest presentation brought to you by Ruth Dennis and Vista Living in Santa Fe. I'm going to pass it on to Ruth. She can do her little spiel and then she can introduce her guest.
I'm Ruth Dennis. I work with Vista Living Care. We do Alzheimer's care. That's all we do. That's what we focus on. I have known Valerie because of her work with some of our I've known Valerie too, but I've known Julie through the work she's done with some of our families, and really gets Alzheimer's, but also really handles delicate and difficult situations quite well, which is the subject of today's talk. The other thing I just have to put out there is something to say is next week's talk, you will end up with me doing part of the talk and then all 4 of the guest speakers from this series as kind of a discussion group and panel. So anyway, I will hand this to Julie and thank you very much.
And thank you, Ruth, and everyone else. This has been fun. Last week was a little easier to put together because I just had to kind of repurpose some stuff. This week I had to do it from scratch. So anyway, I have some extra stuff that I included, just like I did last week, some extra documents, and then of course the slide presentation. And I'm going to try to see if I can get it to share screen. We talked about it a little bit beforehand to see if we could do it. I mean, I figured it out last week, so push comes to shove. Dana, I'll look forward to hearing from you that it's doing what it's supposed to do. So I'm going to do a share screen and see what happens. Okay. I'm going to give it a second. I'm going to try and go to the slideshow itself. Did it go, Dana?
Hold on, I still see the full PowerPoint, Microsoft PowerPoint screen.
Okay.
It did not switch to
Did not switch.
full to full screen of the PowerPoint.
Okay, let me stop share and try it again and see if we can get it to work. Okay. Okay, what do you see now?
I see the full screen of the PowerPoint.
Awesome. Okay, so with that, let's see if we can figure out what to do when things get messy. And I wish I had great answers. Unfortunately, anytime we're talking about legal stuff, I don't know that it gets it more clear or just makes it more messy. So we're going to talk about some of your options so that before we go all the way to the guardianship and conservatorship. And, you know, the first question is always capacity. Then we're going to talk about paperwork when there is no capacity. Consulting a lawyer. Let me say this again. Consulting a lawyer. And we'll talk about that. You'll hear me say it over and over again. And then I'll give my little spiel. Healthcare surrogacy was something we talked about last week. I'm going to talk about long-term care and some of the different types of long-term care ways to get it paid for. And then guardianship and conservatorship, which may you never have to go down that path. So with that, first, let's talk about what is capacity. Does the person have capacity? If they do, then get thee to a lawyer, and if possible, maybe get them to, you know, if you can't do that, at the very least, do a statutory power of attorney. Though I will say that statutory powers of attorney are a little bit, they're not up to snuff with what the law now provides. And so there are other pieces that a good, robust power of attorney can provide that are not in the statutory powers of attorney, both on the healthcare side and on the financial power of attorney side. But if you can't do anything else, at least do that, because basically, if you can get, if we talked a little bit about it last week, if we can get them to the doctor and at least have the doctor say, or healthcare professional provide that, you know, a brief assessment, yes, they've got at least capacity to be able to select who their powers of attorney should be. That's a start in the right direction. I had a case not too long ago where with the wife, her husband was getting ready to be admitted to one of the facilities here in town. And she told me when the doctor's appointment was. We scheduled the power of attorney signing the same day for later that day. And by doing the power of attorney, while a power of attorney cannot do a will on behalf of somebody else, they can do a trust. And so we were able to go ahead and get that in place so that we could go ahead and do the trust. And that way it will make things much easier upon first death and upon second death. of that couple. So having those two things done can help because as I said, it might help with the trust. And sometimes keep in mind the capacity level for a will is pretty low. And so if they can do what's called determine what the object of their bounty is, which is usually their kids or their spouse, that might be good enough. But usually what I want to do is anybody over the age of 80, and if they're younger, but there are some other capacity issues, or other healthcare type issues, I may have them get a doctor's note before I will actually have them sign on the dotted line. So we usually coordinate that so we can have that in the file so there's not problems later on. So what happens when we have no capacity, but we got paperwork? So the first thing is breathe. Just breathe. Because when you look at the paperwork, you may just be going, I don't get it. I don't get it. I don't understand it. Don't be intimidated by it just because it's a legal document. Just don't. So the first thing to do is to go ahead and just sit down, best time of day, whatever best time of day is for you to be alert, whether it's in the evening or in the morning. Sit down with a cup of tea and just start reading, and stop reading when it quits making sense. Make sure you make a copy of the document you're reviewing and then write all over that document. Ask questions, put stickies, do whatever you want to do. And once you've done that and you've looked at it, then at that point, what are you going to do? You're going to consult a lawyer. And what you do is you go and you talk with the lawyer and have the lawyer look at it, because they may be able to say, well, this is what this means under, within the context of New Mexico law. And keep in mind that if you have a power of attorney that's out of state, that's okay. As long as it's a valid power of attorney for the state when it was sought in the state where they signed, that's okay. It's still a valid power of attorney, whether healthcare or otherwise. The reason I say this is money well spent is because you don't want to step over $1 to save a dime. And a lot of times, when you make that call and you find out how much it is to do an hour consultation or even a 30-minute consultation with a lawyer and have them review the document, it's expensive. However, that's sort of that comes under that ounce of prevention as well, because by having that easy conversation, and sometimes the lawyer can answer, I've answered questions just on the phone. I had a case not too long ago where they came in and they had not consulted with a lawyer. It was a probate, and they had made a distribution they should not have made to a beneficiary. And as a result, now it's going to cost a fortune to get that money back. And that could have all been prevented with just a simple phone call that said, whatever you do, don't do that. Don't delay, don't procrastinate on this, because if you think that, it may not be yet that you're serving in that role, fiduciary role. We talked about what a fiduciary meant last week, which is a power of attorney or a trustee or a personal representative / executor. If you think you're going to be serving in that role and you have the documents, go ahead and meet. So that way you know what to do when it starts and you're not just overwhelmed, because this stuff never usually happens on a nice, sunny, easy day where you're like, let me pull that out and think about it. It's always crisis. So if there's some preparation you can do on the front side, that's good. And no, common sense is not your friend here, because legal stuff isn't necessarily common sense. And as a result, you can get yourself in some trouble. So make sure that you at least consult with a lawyer for whatever documents that are operating that you are having to use in order to work on behalf of someone else. And don't forget, because we talked about this last week, one of your other options is the healthcare surrogacy. And, for about 30 minutes of a lawyer's time, we can get this drafted up and done. It's not a big deal. You can look online. I think there's a form, but I don't recall right offhand. This is when you can't use a healthcare power of attorney, but the person has indicated they would like you to serve, or you have been the one that's been serving and making decisions. This is a way to make life a little easier for yourself if the person is moved from one facility to another, from one hospital to another. Keep in mind, though, that the HIPAA release is not part of this because they're not signing a HIPAA release. So you have to kind of jump through a few hoops. Usually the healthcare professional just talks in front of the person, even though they're incapacitated. So that way they're not technically violating HIPAA. So let's talk about the long-term care payment and what your options are in regards to this. Because one of the things that happens is that you end up with, you may even have paperwork, but you're like, they don't have the money to do this. What are we going to do if they end up in an assisted living or a skilled nursing facility? And so this is when you end up going down a rabbit hole of different options. The first one is Medicare. And keep in mind that Medicare only pays for up to 100 days in a skilled nursing facility. And if you would like, I would ask that you pull the comparison of 3 Social Security programs. It's one of the attachments I gave you besides the slide. And it talks about comparison of Medicaid and Medicare on the second page of that document. And on the first page, it talks about Social Security income and Social Security disability income. And so we're going to come back to that in a second because we're going to compare the Medicare and Medicaid just real briefly. But and by the way, these 2 comparison charts come from Nell Sale, who is out, her firm is out of Albuquerque. And I want to make sure I give credit because these are such great charts, and I refer to them regularly because I never can keep up with SSI and SSDI and which one gets paid what. So if somebody is under the age of 65 years, then SSI or SSDI is going to apply, and you can see the comparison chart and how that works. Social Security is also on that comparison chart. Think of the SSA only as retirement because that's all it is. We know how all that ends up playing out. But for now, we're just talking about SSI and SSDI. If you do have somebody who is on the cusp and getting ready to receive Social Security retirement, you want to make an appointment with Social Security because sometimes they can take advantage of a spouse, even though they're not married to that spouse anymore, or that spouse died, and they may be able to take better advantage and then later take their own Social Security or vice versa. So you want to check on that because there's some strategies around the best way to get the highest amount of Social Security over the long haul. And so keep that in mind. Now, looking back at comparison of Medicaid and Medicare, you'll see that if you look at that chart, it talks about what Medicare does, and then it talks about what Medicaid does. And you'll see under Medicare, it says 100 days, like we talked about. And then under Medicaid, it talks about in-home care programs, skilled nursing care, long-term care. And the thing is that Medicaid, and we're going to talk about Medicaid some more here in a second, not necessarily the best approach, but it is an approach. And what I mean by that is there are facilities here in Santa Fe that I would never send a loved one to that are Medicaid beds. And so, and there are, if you are having to look at that option, my suggestion, look in Albuquerque, there are a few good Medicaid beds there. But in Santa Fe, I'm not seeing any because they're not like the Vista Living Care facilities or the higher end facilities. These are facilities that really are just almost just a bed and some food. So with a little bit of nursing care thrown in. You also have VA, and that's an option. We talked about the VA pension last week. Not the same as retirement pension. And we'll get to a slide on that here in a second, and I'll get you back up to snuff on that. And then, of course, there's long-term care insurance. And if I could just put 16,000 red exclamation points after long-term care insurance, I would. And not for the reason you're thinking like, oh, go get it. Of course, that's a good idea, but it's expensive. But it also, if somebody has it, you want to make sure that premium gets paid. And I'm going to wrap around on that in a minute. So let's talk about Medicaid. And as you can see, it says sick and broke. And that's the thing. In order to qualify for Medicaid, first of all, if they have VA benefits available to them, they have to go down that VA corridor first and get denied there before they can show up at Medicaid. Because all that will happen if they go down the Medicaid corridor is they'll end up getting turned back and say, go down the VA corridor. And once you've gone through all of that, then come back to us. And so Medicaid, sick and broke. And so the sick part means that they require nursing home care. They're 65 years or older. They've had institutional care for at least 30 days. Of course, they're a New Mexico resident and they're disabled. So that's pretty straightforward. The broke part is not so straightforward. And so I'm going to talk about a few of these pieces, and it's going to be confusing, and understand it just is. It's confusing. And there's a lot of moving parts that happen in this realm. And I always recommend, again, consult with a lawyer. There's an exceptional lawyer there. There's several exceptional lawyers. Marianne Green is one of them. Susan Tomita is one of them. They're both down in Albuquerque, and they are people I reach out to regularly because I do not do a Medicaid practice anymore. So let's talk about it. Broke. First of all, what Medicaid is going to do, what the state of New Mexico is going to do, is they're going to do a 5-year look back. So when you're gathering documents like we talked about last week, remember we talked about the black box and the gathering of documents, either on behalf of yourself or for a loved one for whom you're caretaking. This 5-year look back period, they're going to want to look at all of the bank statements, some of the other documents like tax returns and all of that. So you're going through everything, trying to find all this stuff. And, you know, the thing is, I was laughing with a client the other day, and she was talking about taking care of her dad. And she said, you know, I need to find 5 years worth of bank statements. What am I finding? 30 years worth of utility bills. So it can be a bit of a challenge. So let's talk about the 5-year look back, because what Medicaid is going to do is they're going to say, how are you spending this money? And so are you spending the money on the care for the applicant or the spouse of the applicant? Have you paid debt with it? Have you purchased exempt assets? You'll see those down below. Are you making repairs or upgrades to the house? Those are A-okay. So this is a time that if you're going to, and you're going, should we make upgrades to the house, you know, for mom? This is the time to do it. Go ahead and make those upgrades. And that doesn't go against you in how money is spent in order to do the spend down, so that your countable assets are down to that $2,000 that we're seeing there. So pay an attorney for the Medicaid qualification, the consult, whatever needs to be done. Usually, an attorney can charge somewhere usually around the first month's disability payment, or Medicaid payment, which, you know, is usually around, I think around $6,000 or $7,000 or $8,000 depending. And so, so that's usually how they are paid, is they get paid that first amount. So what happens with the 5-year look back? And you're like, trust and special annuity strategy, what's that about? So what happens is when you've got that 5-year look back, sometimes what we do is we plan for it a little bit, and we go ahead and take the assets, if there are some, we take those assets and we dump them into a special type of trust. And there's a special annuity strategy that we use, because if they look back and they say, we don't like how you spent $50,000, so we're going to penalize you. And because I'm not great at math, we're going to say it's $10,000 a month is what Medicaid would pay. We're going to penalize you for 5 months so that that $50,000 gets paid back. And in the 6th month, even though we've approved you, we're not going to pay you. And in the 6th month, we'll start paying that $10,000. So that with a trust and special annuity strategy, what you do is, in order to try and preserve some of the assets so that they can be used by the beneficiaries later on, and kind of, as I call it, it's a wink, wink, nod, nod trust, because even though that person is not a beneficiary of that special type of trust, in actuality, they give money back to help the parent or whoever. And so what happens is there's a penalty phase, like we talked about. And so because they've gifted this money to an irrevocable trust, and they create an annuity that pays out and pays during the time that that penalty phase is working. If you go ahead and get qualified for Medicaid, but you still have that penalty phase that you're having to pay, and that person dies during that time period, then you don't have, and I'm going to ask you to look back at your chart, your Medicaid chart, and you'll see at the bottom, it says contribution reimbursement required. Then it says estate recovery, yes. And so what estate recovery means is that they could come after that house. They could come out unless you meet certain criteria, such as a disabled person living in the house or a caretaker living in the house. And I think it's 2 years. So there are other ways that you can get around that. Fortunately, unless this has changed over the last couple of years, Medicaid in New Mexico is not aggressive about the clawback or recapturing of assets that may still be out there. And so now you're thinking, well, yeah, but instead of getting a lawyer to do a trust, couldn't I just put it in my own name and then, take care of mom that way? And yes, you could do that. There's a downside to that. And that is, if you end up hitting the proverbial bus and they sue you because, kids were maimed or killed or whatever, and you have this nice account that's for mom, and it's in your name, they can come after that. And you can't just say, but wait a minute, this isn't really my money, it's mom's money. That's not okay. They can still take it. So that's the downside to doing it that way. Now, if there's gross income of less than $2,500 a month, you're in good standing. However, if you have income, for example, you have Social Security, maybe a pension, and it's over that amount, there's another kind of trust you can do. And so there are things that can be done and some strategies that can be used around all of this. It's suggested, again, you talk with a Medicaid lawyer. Exempt assets. There are other exempt assets, but they're more fancy in regards to how you move around them. The residence, for the most part, is exempt. I mean, unless you have a high-end residence, it's probably exempt, which means it doesn't count towards that $2,000 that we see above. Term life insurance, one car, and it can be a good one. Burial plans, household goods, that's what HH means, personal effects, and interest in a bona fide business. Obviously, not some business you threw up there all of a sudden that you say is bona fide. So let's see, did I cover? Yep, I covered everything. So let's move on to the VA slide. And the VA slide there's no change from last week when we talked about this before. If the person is, if the veteran has been there for 90 days, I think it was, and has served 1 day during wartime, and it doesn't matter that they be in battle, they could be sitting safely in Fort Hood, Texas, it doesn't matter. As long as they have that, they have 2 activities of daily living that need, where they need care. The family income is spent on care costs. This is needs-based. And remember, just go back to the guy, but look for that DD 214 because that's the thing that's going to help you. It's got everything it needs on it to be able to help you navigate with the VA. And so let's talk about this long-term care insurance. As I discussed before, pay this premium. Before you feed them, pay this premium because this will make the difference between being in a Medicaid bed and being able to be in a much nicer facility. And so make sure they pay that premium. Sometimes there are certain limitations. There are some great policies out there. Some are even hybrid, which means they have a life insurance component to them. And so if it's not used, then it'll be used for life insurance. Go through all the paperwork. Look at the bank statements as soon as you possibly can. This can be paid annually. It can be paid monthly, but you want to make sure it gets paid. I've had a colleague who was out of state, had some health issues, ended up in the hospital and bridged 2 different premium payments that did not get made. And as a result, lost his long-term care insurance, which he needs. And he didn't have it. So make sure that you find it. If you have the actual policy, it'll tell you certain critical pieces of information, such as, 90 days before it activates and kicks in, or how much it will pay and for how long it will pay, whether the policy is stackable, because sometimes you can stack 2 policies or have them sequential if you have more than one. And first and foremost, just like you would call a lawyer, in this instance, contact a representative for whoever that person, whatever company that is. For example, New York Life is fabulous. Anytime I've had to work with New York Life, they've been wonderful. They make it easy. They're willing to help. They're not trying to figure out a way not to pay. They're just fabulous. So make sure that you get in touch with a representative because this can make your life so much easier if finance-wise. So that gets us to something here. Let me see. Yeah. This gets us to the hardest path. This is guardianship and conservatorship. So take a deep breath. Put all those other options behind because now we're talking about the big gorilla. And this big gorilla is it's not easy to navigate. So what is a guardianship? And this information, you've already been provided it with the slides. And so because of that, I'm not going to go into the weeds and tell you exactly what it says because it's right there on the slide. Just know that guardianship is mostly over the body. We'll talk a little bit about that in a minute. And conservatorship is over the money. And just keep that clear. So the definition for incapacitated person, again, it's in the slide. I'm not going to go over it here because I think everybody can read. So let's think about when you hear the words GNC or guardianship and conservatorship or any version thereof, just think expensive and onerous because this is a real pain and it can get really, really expensive really, really quick. Now, it is paid by the estate of the incapacitated person. And I use the quote IP for incapacitated person, so I don't have to put this long thing in the rest of the slides. It's expensive on the front end because you have 3 different professionals that are required for the initial guardianship and conservatorship action. And we're going to talk about those professionals in a minute. And then you have several court hearings that you're preparing for. And anytime you hear the word court, just know that's going to be really, really expensive because lawyers have to prepare for court. Then they have to go to court. If we're sitting in court, because now the courts are starting to open back up, then you're paying the lawyer for travel time and what I call fanny time, which is meaning they're sitting on their fanny while another court hearing is happening before their court hearing, your court hearing happens. And so that gets expensive. And at our hourly rates, you want to avoid that if you can. So why is it onerous? I mean, we've talked about the expense, but why is it onerous? The court hearings themselves are, that's so challenging for anybody who is inexperienced with court, or even if you are experienced with court, it's challenging. It requires all sorts of reporting. And we're going to talk about that in a second. And at any time, this thing could be modified. Get past your final hearing, you're like, woohoo, we got through that. It wasn't so bad. It wasn't as bad as that crazy lady said it was going to be. And then somebody comes out of the woodwork and makes a complaint, which we'll talk about at the very end. And every 10 years, you've got to have one of these blasted hearings. Now, you don't have to have all the same people on board, but there is a professional or two that does have to show up and do an investigation at some level. So we're looking at the professionals. So who are the professionals? Because I mentioned 3+, right? Well, then, of course, the petitioner, who's the person who's applying on behalf of the incapacitated person, may have a lawyer. They don't have to. And we're going to talk about how you can do this on your own. And then you have the guardian ad litem, and that's the person who represents the best interest of the incapacitated person and is the arm of the court. They're the ones that kind of pull all the data together from these other representatives to make sure, these other court appointments, to make sure that the court has all of the information. You have the court visitor, and you have the qualified healthcare professional. The healthcare professional pretty much is a one-stop shop. They come in, they do the evaluation to determine that the person is incapacitated or somewhat incapacitated or not incapacitated, and they write a report. All these people have to write reports. I don't know about you, but anytime anybody is writing a report, no matter what kind of, what they do for a living, that always takes time, and they're pulling all this data together. The qualified healthcare professional, if the person is already located in a facility, and we did this that's how Ruth and I met, was on a guardianship and conservatorship a number of years ago. And we were able to use the physician that came to that facility on a regular basis to assess that person. And so it saved some money, and it also saved a lot of headache because we were able to get that done. So these are all the players. And sometimes you can avoid having to have the qualified healthcare professional show up. It just depends on if there is, some questions about whether the person is fully incapacitated. If it's pretty obvious, then there are ways to avoid having to have that person appear. So give me 1 second. Make sure I cover everything. We're going to come back on this in regards to, I can just talk about it now. You have to follow the same evidence rules, whether you're a lawyer or not, and they are required to be followed in these guardianship and conservatorship hearings. And if you don't follow them, you may not get certain evidence in. For example, there's some little tricks of the trade that lawyers can do, and you can consult with a lawyer just to help you get your stuff together in order to do the presentation. So you don't have to have the lawyer at the hearing. You just use the lawyer to help you through paperwork and then to help you with the hearing. So you can use them piecemeal. And lawyers understand. We're not going to say, oh, no, we're not going to do that. We're more than happy to help because we understand the expense. So here's your resource page. And anytime you're dealing with any sort of legal proceeding, and in this case, you're talking about the statutes in New Mexico dealing with guardianship and conservatorship, everything is contained there for the most part that you need to know. Look at those definitions, because those definitions tell you what these words mean and how they're going to be applied by the court. So as I said, and you see it there on the slide, consult with a lawyer. Consult with a lawyer once you've filled out your paperwork, so that way they can say, oh, don't do that. Make sure you put this. Because there's, as I said, there's little tricks of the trade. You do have fantastic resources in New Mexico. First of all, you have at nmcourts.gov, you have all the resources you need in regards to adult guardianship. You also have a requirement that you watch certain videos, and it talks about it in the nmcourts.gov website, what videos you're required to watch, because you'll pull the certification that you have to file that says, I've watched these. And it'll say, if you're guardian, you watch these. If you're a conservator, you watch those. And so there's a couple of places you can go, and I've listed them there. You also have the forms themselves that need to be filled out. There's nothing fancy. You can just fill it in, as long as you don't have serial killer writing, but actually have good writing. This is the time to do your third grade good writing that you get graded on, so that it's easy to read. And then last but not least, you have the New Mexico Guardianship Association. The reason these forms and these videos are available is because the New Mexico Guardianship Association has done a ton of work over the years in order to make this more accessible to people who cannot afford a lawyer. And so as a result, you have the NM Guardian Association. So you can go there and you can join for $30 and you can get some nice benefits, or there's still stuff you can get. You can get their handbook and you can download that. And there's a lot of practical information. I am going to tell you, it is out of date. So there are forms, there are things they'll say you need to do in court that don't apply anymore, because there's been changes in the law, and there's been substantial changes in the law since 2014 when that handbook was put together and published. However, as I said, there's a lot of practical information that's invaluable that's in that book. So go ahead and pick it up. And so let's say you've kind of done your research, you got it all kind of set to the side, and everything seems to be going swimmingly until the your sibling that's the bad brother or bad sister, or the sibling of the incapacitated person all of a sudden shows up and starts making things difficult and deciding that mom needs to put her on the bank account, do some of those things, which, by the way, putting somebody on the bank account, if you go to the guardianship website, it talks about that as an alternative option. And it is an option if you're the only child. If you're not the only child and your name is the only one on the account, when mom dies, then the account goes automatically to you, which may not be what mom wanted. So keep in mind that that may not be what's needed. It may be okay if you understand that you got to give half of it to brother. But if you have an emergency, what we're looking at right here is a change in the law that takes effect July 1st. So if you do something previous to July 1st, most of this applies, but it doesn't have any date associated with it. So you do a petition, and you say in the petition, hey, this person is incapacitated, and you fill it out and do all the things you're supposed to do. And then you have a separate motion that you do in order to make sure it gets before the judge right away. So that way somebody can be appointed to take care of mom if things are going south. So this The standard is serious, immediate, and irreparable harm. And if it's for the guardianship, G, then it's the health, safety, and welfare of the incapacitated person. And if it's C, conservatorship, then it's serious, immediate, and irreparable harm to the incapacitated person's estate and or finances. And so the court can do a couple of things. If you've attached an affidavit, for example, you've already gone to the doctor and they said, yes, mom is incapacitated, you can go ahead and attach that affidavit. And you can also ask that that person be appointed to do the official assessment of whether mom's incapacitated. And the court can go, oh, okay, well, we're going to go ahead and enter an order that says that you, daughter Susie Q, can be the guardian on behalf and or conservator on behalf of mom, and we'll have a hearing in 10 days. And they also can just go ahead and say, no, I'm not going to enter that order now, but we will have a hearing within 10 days. And then I'm going to enter an order. But if you have the affidavits attached that are needed, it's more likely that the court will go ahead and enter an order. And you have to give the court the proposed order, by the way. And it's in your forms. It's all on that nmcourts.gov. It's a wonderful site. So what happens if it's not an emergency? Well, you have to have a permanent hearing to, of course, take away somebody's rights, because it's a constitutional right that you get to make all these decisions for yourself unless you are incapacitated. And the incapacitated person or the petitioner / applicant can request a jury trial. Not recommended, but that can happen. It really rockets the costs and expense. But a permanent hearing has to be had to determine what the guardian can and cannot do, if a guardian should be appointed, and the same thing on the conservator side. And like I said, the evidence rules apply. So you got to make sure you jump through the hoops the right way and be aware of that. And the petitioner must prove by clear and convincing evidence that a guardian or guardianship or conservatorship is needed. You're like, what the heck does that mean, Julie? I don't know what that means. So let's think about the criminal side, because everybody always has watched enough court TV that they know that, it's beyond a reasonable doubt on the criminal side. This clear and convincing evidence right below that on the civil side. So you really have to have your ducks in a row and make sure that you've proven up that this person needs a guardianship and or conservatorship. This hearing is now public. Used to be that these were private hearings, but they're not anymore. They're public. That doesn't mean the documents are, but the hearing itself is. And any old schmo can wander in, whether it's on a Google Meet, which is how courts meet during COVID, or in person. They can just wander in and watch. They don't get copies of the documents unless they make an application to the court. And so how long does this take? In regards to the temporary, if you've made a request for temporary guardianship or conservatorship, the go-to starting July 1st is 30 days. You got to have a permanent hearing within 30 days. The court can extend that upon request up to 90 days. If you don't have a temporary guardian or conservator, it can go on for years. I've got a case that's gone on for 4 years now. And so a hearing must occur within that 30 days or up to 90 days before. If it does not, then at that point, technically the court loses jurisdiction and you have to start all over again. Sometimes we kind of fudge around a little bit, but just keep that in mind. So if you have a permanent, you haven't gone for temporary, you can just wander along as you go. If you've got a temporary guardian or conservator, you've got a really short time frame and you got to be ready and you got to hoof it. So What are these reports that we talked about earlier? What are they? If you're a temporary guardian and under the temporary conservator and guardian stuff that I have on the slide, this takes effect on July 1st. It's not required for anything previous to that date. If you're a temporary guardian within 15 days of appointment, and you have to have a guardian report. These report forms are available on nmcourts.org. And then within 15 days after the temporary appointment ends, then at that point, you have to do another report. And as the temporary guardian, if it's the same person that's going to be the permanent guardian, 75 days later, because 90 days from the date of permanent appointment, you have to do another report. On the conservator side, what they require is something called an inventory. It's still pretty extensive, but that has to be done instead of the full and complete report, which is required at the second 15 days and also at the annual stat when you do the annual report. And the annual report takes some time. It's pages and pages long. It's date from permanent appointment. You've got a little bit of squidge room that you can file that, but just know that it's pretty much within 1 year of the date of appointment when you are the permanent appointee. On the permanent conservator side, you will see that there is a $25 per day late fee until that annual report is filed. And guess what? That's not paid by the estate of the incapacitated person. That's paid by the permanent conservator who didn't get their act together. So keep that in mind because that can add up. Let's see. So what are some of the basics? The basics are, get to, in regards to the powers and duties, when you get the order to serve as the guardianship or the guardian or conservator, when you get that order, at that point, give me 1 second here. At that point, you get an order that says you've been appointed, because there are certain things that under the new statute, you can't do as a temporary guardian or a conservator unless you get a court order that says it's okay. An example would be as a guardian, you come in and you're temporary guardian, you're like, we need to move mom out of this horrid environment. She's, her health is at risk because she can't clean up. She doesn't understand. The refrigerator doesn't work. There's fecal matter on the floor from pets or from, or from rodents. And so we need to get her moved. And you just think, what I say, common sense isn't a good thing in a legal matter. And this is one of those cases where you're like, well, yeah, but I need to move mom out. Yes, you do. Make sure you state that in your motion up front so that way you can make sure that happens and you can get her out of that environment ASAP. So, but otherwise, in regards to powers and duties, you get that order, you get that letter, you're now the permanent guardian and you can make decisions or you're the conservator and you can make decisions. And keep in mind, the goal on both sides is that you have the least restrictive form of intervention on behalf of the incapacitated person. So for example, if they're able to make their healthcare appointments, they just can't figure out how to show up for them, then they need to be allowed to do that. They need to be allowed the slight bit of autonomy they would be entitled to. And that's also true on the conservator side. Maybe they're good at writing their monthly their monthly checks because they've done it for so long that they can't make decisions like how to get their tax return filed or how to manage a financial account. So that basically, keep in mind also, let me see. Oh, here we go. Attachments, you have the general powers and duties of the limited guardian and guardian. I've attached that. It gives you what those powers and duties are. On the conservator side, I've given you 2 statutes dealing with the powers of conservator in administration and what they can do, because it's a little broader with the conservator, because you can also take care of other people upon who the incapacitated person supports. So you have those available to kind of give you a jump start. So let's look at the next slide. So these are some basic factoids in regards to a conservator proceeding, because there are things that a court itself can do without a conservator ever being appointed. And that is, they can manage all of the estate and financial affairs. Usually they appoint a conservator to do it on its behalf, the court's behalf. They can even create a trust, but they cannot create a will. That is only the person who, the incapacitated person is the only one that has the right to create a will, but you can create a trust. The court could just say, you know what? We just have a problem in regards to being able to deal with the sale of this one piece of real property. And so we're going to do a protective arrangement, and you can just do it for one transaction. So somebody can sign the documents, take care of the closing, put the money into the account, because that might be just a little too complex for the person who is able to pay their bills. So remember, I said the last thing we're going to cover is the grievances and how people can object and how people can make life difficult for anybody who's serving as a guardian or conservator. And so you have, again, on NM courts, which you will curse this, if you're serving as a guardian or conservator, they have a form for a grievance to be filed. It can be filed by any interested person, and any interested person can bring a guardianship or conservatorship. So who's an interested person? First question. Second question, is there a definition? We know where the definition section is now, so that's where we could go. But an interested person is anybody who's interested. That's kind of scary, but that's the way that's what it says. So any interested person may file a grievance, and the protected person can file a grievance, and they can do it against the guardian, the conservator. And here in the statute is where they also talk about the representative payee, who is the person who manages the Social Security Administration check that comes in every month. So they make an allegation of a breach of fiduciary duty. And not only that, they have to be pretty specific, because I'm sitting here looking at the form so that I make sure I cover it. And they have to, if they brought it before in the last 6 months and it's been pretty much addressed already, the court can decline to take any action. And it asks that on the form as well. Has this been addressed in the last 6 months? And then, it asks, do you have any concern for yourself or the protected person about raising this grievance? Meaning, are you afraid that there will be repercussions to you by doing that? And is the protected person or the incapacitated person aware that you're bringing this grievance? And is the guardian or conservator or the representative payee for whom you're making your grievance, are they also aware, and have you let them know? Doesn't say you have to, but it wants to know why you haven't, if you have not. So that takes me to the end of the presentation. Oh, one more thing. There are 2 resources that I want to bring to your attention. They're not in my materials. One is, of course, Adult Protective Services, which I am sure has been covered in other presentations. I just want to bring it to the forefront. If somebody's care is at issue, maybe a file needs to be opened at Adult Protective Services and an investigation done. That itself is one organization. You also have the Ombudsman, who comes under the Department of Health, and they are not under APS, under the Adult Protective Services, they're under Department of Health. And they go into these facilities on a regular basis, and they listen to the complaints, if any, that are made by the residents about the facility, and they kind of just check out the facility. And so these are 2 wonderful resources, though, because Ombudsman, even if there's nothing else, there's no grievance, there's no nothing, they know a lot of resources. So that's one place to go. And with that, I'm done.
Thank you so much, Julie. Lots of information. Before we transition into asking and opening the floor for some questions, it is already 4:33, so if anyone needs to leave, we understand. Feel free to log off from the session. The session itself, presentation portion was only scheduled to 4:30. We are going to stay later to answer some questions, but just feel free to get off if you need to leave. For the folks that want to stay, we are now going to start opening the floor for questions. There are a couple in the chat that I think I want to start with since they're already in the chat. So let me get those, one moment. Valerie asked in the chat, how long and what does it take to do a trust? How long does it take and what does it take to do a trust?
It takes, I'm trying to get this to allow the chat to show up, but anyway, I have done a trust in 2 days before when I had a deathbed trust I had to do. And it was even during the beginning of COVID and we had to go through all this stuff. But it was a pretty straightforward trust. It depends on how involved the trust is. Sometimes you don't need a trust. But let's say you do under the things we've talked about today, and we're doing a trust. It depends on how complex it is, what we're trying to accomplish. As I said, if you're doing a trust that's coming out of one of these things we've talked about today, it's probably going to be pretty simple. And so that can happen fairly quickly. The downside is that, like I said last week, most of us estate planning lawyers are pretty busy. I'm scheduling out about a month. So that can be a problem. But if we really have to get something done, we can. I know that wasn't a good answer, but that's the best I can offer.
And then how much would it cost to start that if it's around a month?
A trust, my retainers on a trust start about $350. My hourly rate is $350 an hour. I mean, $3,500 and my hourly rate is $350 an hour. And depending on how involved that trust is, depends on how much time it takes. A lot of the work, as long as I try to get all of the data up front that I can so that the clients are not, we're doing it as quickly as we can. If it's a really simple trust, sometimes what I do is I don't use my software that I have. Instead, what I do is I use somebody else's trust that I've drafted before and pull it together, which means that it's a lot cheaper. It just depends.
And then does it matter which state then you do that trust in or no?
No, not really. For example, there are certain types of trusts. I talked with somebody today where they really didn't want to yesterday, where they didn't want to get divorced. But he had an alcohol issue. They didn't want to get divorced, but they wanted to protect assets. And I said, you could do a particular type of trust, but you need to go to one of the states that has that. So you can go, typically you have the trust done in the state where you reside. It's easier that way. But there's not anything that requires that happen. It just usually is the better way to do it because all the resources you need to be able to support that trust and to make sure that everything gets funded into the trust. Because one of the things that happens is people think, oh, I got a trust, I'm done. No, you're not. You have to fund everything in there. And that's a whole nother topic that, that I talk about at the beginning of estate planning with my clients, is because once it's a trust, all you have is this empty shell. You have this container document. Now we have to put stuff in it like the house, or, you don't put a car in there, but you do put stuff like investment accounts. You don't put IRAs in trust. But you go ahead and you dump all that stuff into the trust. So that way it's where it needs to be. But if you're doing a Medicaid trust, that's a whole.
Okay, thank you.
The next question in the chat is from Laura. It says, do you have an experience with the PERS, PERS system? It's a University of California employee benefit.
Pretty much the benefits, I don't, work directly with the various, we have para here in New Mexico, they have para in Colorado. It's a pension, if it's a pension system or a deferred compensation system.
It's a long-term care insurance policy.
Okay, then no, I don't.
Okay,
You would still pull that information and make sure you had it. Remember last week we talked about the black box. You want to make sure that data is there and you want it easily available to your fiduciary, whether that be a power of attorney or a trustee or whoever. In that instance, it'd be a power of attorney. You want to make sure it's readily available and you want to know what the terms are. And you might even do a little summary on behalf of your, for your agent so they know where to go and what it is and what it'll do for you.
okay, thank you.
Can I offer up one that I've seen families get burned by on long-term care insurance, which is some policies operate on a daily rate only and others have a spending amount. I've had elders get burned because they had a daily rate that was so low that it wouldn't cover assisted living. And they were kind of forced into a Medicaid nursing home, even though they had a long-term care policy.
Yeah, and that can happen because the premiums are expensive. So you have to always look at that policy and go, is there a way? I mean, because usually it's a supplementation from something like your Social Security benefit or your pension. It's a way to make sure that you can be in a nicer facility, but it's not going to pay all the costs.
Okay. Actually, I have a long-term care insurance policy. My partner, who is the one with Alzheimer's, does not, but I still was curious if you had any experience, that's all.
Yeah, and what I always tell my clients when it comes to long-term care, and I always ask that question, and it's in my intake form, because I put special language in the power of attorney so that it basically says, before you feed me, pay my long-term care insurance.
And you're right,
And
it's
make
not,
sure,
it's,
as I said, make sure that's in your black box and you make
yeah. And I have heard from other
fiduciaries
people.
know.
I have heard from other people who have used it that it's a good system, but it's not cheap.
No, it is not cheap. And like Ruth said, some of these policies, it's sort of like really bad life health insurance. You can have really bad long-term care insurance too.
Yeah.
And
I'm
I've
sure.
also seen incredibly good ones. So,
Yes.
Yeah,
New York Life is fabulous. I found them to be wonderful.
And another point too that I need to bring out is the VA. Aid in attendance for several of our elders has meant the difference between being in a nursing home and being in assisted living. Because even though it wasn't the full amount, it was enough to bridge the gap.
Absolutely.
Can I also bring up one more thing and not be a pest?
Please do.
The role of, one of the things I do for elders, and I have done for elders, but when I was going through Morgan's stuff with Medicaid was also important, is what I call the To Whom It May Concern letter, which is a letter basically from a professional vouching for your credibility in someone's care or for someone's needs. I've done To Whom It May Concern letters for Julie before for one of our elders.
Okay.
So don't be afraid to ask for that.
Those were the only questions that I found in the chat. So if there's anyone that has a question that maybe didn't write it out and wants to ask it now, feel free to unmute.
You have a $350 coupon right now. Or forever
That's
hold,
true.
forever hold your purse.
That's true.
Well, and the other one, and I just have to put it out there because some of you guys are family caregivers. And I have to put it out there by admitting I'm a hypocrite. Many family caregivers do wonderful paperwork for the person they're caring for, but do their own. I'd love to have a survey of how many people work in healthcare who don't have a power of attorney, a living will, or a will. And I'm one of them, you know. So do your own as much as you do the person you're caring for. Don't kick your own down the road. Laura's nodding. You're muted.
I just said, agree. Amen. Yes, please. Yes.
I think an underrated thing for caregivers is caregivers also have to know how to protect themselves.
Absolutely. And one of the things that I haven't mentioned is, and it's clear in the guardianship and conservatorship statutes, it is not a requirement that if you serve in those roles, that you use your own money. You are only required to use the incapacitated person's money. And there is no requirement by the state that you use your own money to take care of any of it.
Okay, I'm going to do one last call for questions. This is a great opportunity for you, like Valerie said. You have the chance to actually ask an attorney your questions right now. So any last minute questions?
I also put my email, somebody had asked at the beginning, and I put my email in the chat feature. Feel free to reach out. We have to go through something called a conflicts check first to make sure that I'm not doing anything that is contrary to some other previous client we had at some point that was adverse to the person for whom I would be giving advice. So we always have to do that. You'll go through kind of a protocol through through Marshall or Kate. And, you could just say, I was one of the ones who heard the presentation, and I'll try and do my best to try and squeeze you in somewhere so you can add, if you have a private question you want answered, that can be done. I don't mind.
Thank you so much, Julie. Oh, sorry, Ruth. Go ahead.
I also think it's really important to be willing to pick other people's brains, because none of us can figure it all out on our own.
Yeah.
So use that email, guys.
Pick up, as we say in one way, pick up that 10,000 on phone. Make a call.
And breathe. And remember, you don't have to get everything done tomorrow. Just take your time, step by step. And we have a really amazing presenter with Julie. Thank you, Ruth, for inviting her. I really love your, I always get mixed up, and you said conservator was the, guardianship was the body, and then the other one was the money, but at least I know that one's the body now.
Yeah.
So that's like helping me remember which one was which.
Right. Yeah.
And next week, if you guys can sign up, it's going to be interesting. I'm going to start from a family caregiver's point of view of kind of what happens in the aftermath of caregiving. And then we'll have all the presenters together.
So Julie will be back next week.
I will be back next week. I won't have any slides. But what I will say is, this is a time to say, because I would like to learn. This has been about me teaching, but I would love next week to be about me learning. And some of it is just the practical aspect. And you're like, if lawyers only knew, if they would just do this, That would be helpful because it may be that I could shift language in my powers of attorney or something and make it a little easier for caregivers. So please know that there is nothing magical about the language we have. It's just the language because I'm always fiddling around with it. My healthcare power of attorney, of course, changed after COVID, and it's changed again. Changes again. And I've got some clients from 4 years ago who called me up and I said, we're doing a free healthcare power of attorney. I want to get this updated language in there for you. So just know that I really would love to learn next week about how things could be easier if lawyers only knew. So.
Well, and one of the pieces, and I always have to say this in Alzheimer's talks, I have seen people with dementia with really good verbal skills really pull the wool and con lawyers and doctors big time.
There's a way you get
that's dangerous.
It is. And the first case we worked with together, he had alcoholic dementia. He was, in his early to mid 60s, I think. And he was as social as could be, and I've served as a guardian ad litem. They're social as could be, but they don't, it's like, okay, where are we in the window? Can they do 20 minutes? Can they do 30 minutes? Can they, are they down to 10 minutes of being able to cycle the conversation around? My mom did a really good job in masking. But you could still figure it out after, you could watch on the phone over years how that window just got smaller and smaller. And so usually, because my consultations tend to be a little longer than just the usual consultation, usually I can pick up that there's a problem.
Sieve it out a little bit.
I think just to remember too that I know we're probably overloading you again, like you don't have to do this tomorrow. So hopefully you can get your questions for next week. Like I said, like we know lawyers are expensive. You're getting a $350 coupon, this is your second coupon and your last one is gonna go out the next week. So if you can think of any questions.
You actually have a chance to get a lawyer, a money guy, and 2 family caregivers and a meditation teacher all in one shot, which is kind of an interesting and weird combo. So
yeah, I'm looking forward to that. That'll be fun.
And it'll also mean a few of my best friends will get to meet each other, which is cool.
Yes, so I definitely recommend, if you're not already registered for next week's class, get registered because you're going to have lots of expertise in one session. And it really is, it's a panel. So it's all of, like Ruth said, there's several of them going to be in one session, and there's going to be even a much larger question and answer session than we normally hold, because that's what we wanted to provide. We wanted to provide all this expertise there for caregivers to kind of bring their questions. So if you're not already registered for that session, I highly recommend that you do.
And for all my people, you are, so don't freak out.
I think my third slide said, breathe. But you really do. It really is. I mean, and don't think just because, it's just a document. Feel free to, do whatever you need to do to be able to go through the steps that we talked about. But yeah, just don't use common sense.
Yeah, and I'm going to agree with Julie on the don't use common sense, because I've seen situations where families will both agree on what level of care somebody needs and still fight. And it's like, what, but it happens, and it's part of what happens. And, the thing I was blessed with my brother is I was in charge, period. And
yeah,
that helped. Not everybody's in that situation.
Yeah.
Well, thank you, Julie, for another great presentation, and thank you, Ruth, for bringing Julie to our program. We're so thankful for these dementia sessions that you bring to us, Ruth, and their guest speakers that you bring along with you. Thank you to all the folks that stayed on past time and asked some questions. And we look forward and hope that you'll come join us back on next Tuesday's session. And we hope you have a great rest of your Tuesday.
Thank you so much for letting me present.
Thank you, everyone. Bye.
Bye.